discrimination against women, CEDAW, International Covenant on Civil and Political Rights, on the rights of child. International instruments include the Convention on the Rights of Persons with Disabilities, African Charter on Human and People's Rights, and recently the Maputo Protocol. These instruments are relevant to the promotion of and protection of the rights of women and girls in South Sudan. More so, this report on the gender analysis of the national laws of South Sudan being launched today further constitute the government's effort and commitment to step towards eliminating discriminatory laws and achieving gender equality in law. UN Women applaud the Ministry of Gender, Child and Social Welfare, the Ministry of Justice and Constitutional Affairs for leading the initiative with the support of UN Women and further funding support from the government of Netherlands. Notwithstanding the positive legal steps, the report being launched today revealed that there are gaps in some of the national laws of South Sudan in addressing all aspects of discrimination against women and girls. And there are provisions in the laws which discriminate and deny women and girls equal rights with men and boys. Of the 26 national laws and one policy analyzed from the viewpoint of the international and regional human rights instruments to determine their direct and indirect effect on the rights of women and girls, 25 of the laws contain discriminatory legal provisions or gaps which negatively affect the rights of women and girls. I just give you an example. Article 15 of the Transitional Constitution of Republic of South Sudan, 2011 as amended, reflects that every person of marriageable age shall have the right to marry a person of the opposite sex. However, it does not define marriageable age as required under the Article 16.2 of CEDAW and Article 6b of the Maputo Protocol, which explicitly provides that the minimum age of marriage shall be 18 years. The lack of definition of marriageable age disproportionately affects young girls as it effectively permits child marriage. Child marriage is a discriminatory practice, contrary to Article 16.1b and 16.2 of CEDAW 32.2 of ICCPR and 6a and 6b of the Maputo Protocol, which prohibit forced marriage and child marriage. In 2018, UNICEF reported that 52% of the female population in South Sudan is estimated to have been married before the age of 18, and 1 out of 3 girls have been impregnated before the age of 15. Section 247, 3 of the Penal Code Act 208 is to effect that rape within marriage does not constitute a criminal offense. Exempting marital rape from criminalization guarantees legal impunity to persons who sexually violate their intimate partners. Yet, marital rape is a form of gender-based violence that violates the right to equality, liberty, and security of persons. Failure to criminalize marital rape constitutes a failure to protect persons against gender-based violence by third parties, contrary to the provisions of Article 2E of CEDAW. And CEDAW Committee General Recommendation Number 35, which recommends that states should implement effective and legal measures, including to ensure that all forms of gender-based violence against women in all spheres should be eliminated. Existence of discriminatory laws in the statute book is a setback to achieving SDG 16, meant to promote just, peaceful, and inclusive societies, especially on the target to promote and enforce non-discriminatory laws and policies for sustainable development. Government has the obligation under the international and regional human rights instrument to eliminate discriminatory laws. Promote and ensuring non-discriminatory law and policies is a fundamental component of the right of non-discrimination, which is a basic constituent of human rights protection principle. The right is protected under the UN Charter, international and regional human rights instruments, and human rights jurisprudence. Therefore, South Sudan, as party to a significant number of human rights instruments, including CEDAW and Maputo Protocol, is encouraged to respect, to protect, and to fulfill the right to non-discrimination and equality by ending gender discrimination in laws by taking positive action in reforming the laws and policies in line with the international and regional human rights instruments that it has acceded to. In closing, UN Women calls upon all relevant government institutions, including the Ministry of Justice and Constitutional Affairs, the Law Review Commission, the Transitional National Legislative Assembly, to work together to ensure positive legal reforms as recommended in this report by A. Amending, revising, or repealing the identified provisions to comply with gender equality standards. B. Stringently implement the provisions of the laws which align to the gender equality norms. C. Develop and enact the identified new national laws, including a national law addressing international crimes to strengthen the protection of human rights in line with the obligations under the international and regional instruments. C. Implement the social policy and related actions recommended in the report to support effective realization of women's rights to non-discrimination and equality. Noting that South Sudan has numerous legislation, it is important that building on this effort, the government should carry out comprehensive audit of all the national laws to inform legal reforms. Also aware that the country is in the process of developing the permanent constitution. The constitution-making bodies should develop a gender-responsive permanent constitution that incorporates the demands and priorities of women as contained in the South Sudanese Women's Charter, which we will be reviewing and validating from the 27th and 28th of September, so tomorrow and the day after. UN Women pledges its commitment to supporting the government and women and girls of South Sudan in the effort to achieve gender equality in law and practice. Thank you very much.